it will come on your portal. Come on portal. How will they do it? आपका आंसर कैंसिल हो. नहीं डीम्ड मैंने कैसे करेंगे? But how? I don't know. Hearing तो hearing का provision नहीं है ना. Therefore there is nobody. There's nobody.
Sir, deemed provision में तो क्या होगा जब portal है ना अपने आप allow कर देगा. Immediately when you finish filing your returns, immediately allow.
बेसिकली वो तो खोलना पड़ेगा, अदरवाइज तो कैंसिल का तो नहीं हो पाता है. फाइल नहीं कर पाते थे ना. कहाँ करते थे पहले तो के बाद तो वो नहीं हो पाता.
Discussing till now there is no automatic revocation. Now there is an amendment. If there is an automatic revocation, whichever way they do, I have no idea. Money. They have added Rule 88B, introduced from retrospectively from 1st July 2017. It says interest shall be paid only on cash component which is deposited. That is, only you had an ITC of 10 lakh rupees, your tax liability was 2 lakh rupees. 2 lakh to deposit paid. So the controversy was whether it should 12 lakh on the whole interest or cash. They have removed this controversy, that you shall pay interest only on 2 lakh which is paid to electronic asset. This is retrospective. This is retrospective. Now here again, if some people have paid interest on gross amount, you have a ground for claiming refund. And section 54 limitation will not be applicable. They have added also sub rule 2. अब इसमें काफी लोग करते थे. वो कहते हैं अगर आपने टैक्स नहीं दिया या शॉर्ट पे किया, then interest shall be paid from the time it became due, notwithstanding what ITC you had in your account. That is supposing आपकी 1 अप्रैल को ITC आपके लेजर में 10 लाख रुपए, कोई आइटम 12% की थी, आपने 5% टैक्स दिया, ABC रीजन, और हमने टैक्स नहीं दिया. ठीक है, अब 10 लाख पड़ा आपके पास, आपकी टैक्स भी 6 लाख की थी सिर्फ. वो कहते हैं notwithstanding what balance you have in your electronic credit ledger, interest on short paid or not paid tax shall be charged till the date of payment through electronic or electronic cash ledger from the time it became due. That is, अगर 1 अप्रैल का टैक्स आपको 9 मई तक देना था, वो whatever the time, तो इंटरेस्ट 9 मई से लाखों. वो आप ये नहीं कहते मैंने तो पढ़ा था नहीं, मैं इतना पैसा. No. So there was a confusion on this issue also. They are clarified. Interest आपको तब से देना है when it became due.
On gross without considering ITC.
हाँ, जो आपने शॉर्ट पे किया साढ़े पर. Yes.
जो remaining रह गया.
साढ़े पे. Yes. This is my interpretation. Absolutely. जो आपने टैक्स नहीं दिया. अगर ये नहीं होता फिर तो अमेंडमेंट की जरूरत नहीं थी ना. That is the only thing they have clarified.
But sir, अगर इनपुट ले लिया और इनपुट रिवर्स नहीं करा और आपने
उसको तो इंटरेस्ट पहलेगी.
उसका इंटरेस्ट पहले वो तो रहेगा.
This is only short paid or not paid. उसका कोई इशू है. So interest on wrong availment only when you avail and utilize. The first example I gave you. Rule 89 sub rule 1. We discussed yesterday. When you supply to SEZ or developer or co-developer and you want to claim back the input tax credit based on supplies made to them, somebody has to certify that these goods were received. Now they have designated a specified officer who will have to give a certificate. Then you will have to obtain a certificate that these goods were received here. If you don't have the certificate, you cannot claim input tax credit reversal. So you cannot claim refund of unpaid ITC for zero supply made to SEZ. कल हम डिस्कस करें कि SEZ में प्रोविजन है. अब उन्होंने उस प्रोविजन को आगे यहाँ डाला. मैंने कल तक नहीं पढ़ा था ये. मैं तो आज सुबह 4:30 बजे पढ़ा था इसको, तो I made some notes. So now this is clear. आपको SEZ की अगर अनयूटिलाइज्ड ITC का रिफंड क्लेम करना है फॉर जीरो सप्लाई, आपको ये सिस्टम फॉलो करना है. जो भी आप रिटर्न फाइल करेंगे, you have to be very careful on this. Electricity exports. In case of NTPC versus State of Madhya Pradesh, Supreme Court examined whether electricity is goods. They said electricity is goods for whatever reason. But when came a Supreme Court constitutional bench judgment in Tata Consulting Services, they redefined the goods. But notwithstanding that judgment, NTPC judgment held good. Electricity is goods, this can be possessed, transport, sold. Right? Now they say that when you export electricity, government has fixed FOB value as a gross value for exports, not the CIF value. If you remember section 15 valuation, where government fixes the limitation on value, that value shall be decided for taxation. Therefore, now they say if you export electricity, which are taken as goods, then your gross value for the purpose of export shall be FOB value, not cost includes insurance rate. But that's very high in electricity cases. So the जितनी जो आपके private electricity player है या government है, they will be hit by this. But few people have to know it violates section 15. In my view, it doesn't violate section 15. You are not importing goods, you are exporting goods. Section in custom act है, imports के लिए आपका valuation है, exports के लिए नहीं है. Therefore, under section 15 subsection 5, government has power, so they can decide what the value for a particular purpose. Therefore, electricity is a big issue decided. If you remember the judgment of Supreme Court VKC footsteps, where considering the Rule 89.5 formula, they said the services have to be excluded because the 54.3 subclause Roman 2 does not allow this. But now they've said the services shall also be part of the formula, but not retrospective. Now this is a horrible thing they have done. So now it is applicable from whatever date is this notification, 5th of July. It is not a retrospective amendment. I heard somebody saying yesterday, somebody talking about retrospective. No, I read it, it's not retrospective. It is from the date of notification. Now from now onwards, now this requires a lot of working at your end, people who claim this refund on services. आपको 4 जुलाई को हिसाब किताब बनाना होगा. 4 जुलाई से पहले आपका सर्विस का इनपुट टैक्स कितना है, उसका रिफंड आपको नहीं मिलेगा. You have to go forward and say how in accounting we proceed further. What in addition to what you already have, what you can claim further. As on cut-off date of 5th July, if you have a service tax unutilized ITC, refund in cash is not available. You can cut it off. But now you want refund in cash, your CAs or lawyers have to be ready कि इस period में आपका आगे क्या मिला आपको. So your invoices to claim refund have to be dated, post-dated 5th July. It's as simple as this. So this is the legal implication of this overturning judgment of VKC footsteps. Now there is an amendment in Rule 96(1) by subclause B. It is retrospectively effective from 1st July 22. जब आपका mismatch और shipping bill में mismatch है exports के लिए, so they have redefined limitation to give more power to the proper officer. वो कहते हैं जब ये rectification होगी, then your date of refund application will be that date. If you want to rectify. तो अगर rectification में 3 महीने लगते हैं और आपकी deficiency memo clear करने में 3 महीने लगे आपको, तो officer को 3 महीने फालतू मिलते. The refund application at 2-year limitation shall be applicable from the date when you rectify this mismatch between GST 2(1) and customs के आधार पर. Right? So what does it mean now? ऐसे हजारों केसेस हैं जहां कस्टम के पोर्टल में आपकी बिलिंग 100 करोड़ की, आपकी किताबों में 90 करोड़ की, जहां कस्टम में आपका जो IGST दिखाते हैं 50 करोड़, आपकी किताबों में 60 करोड़ है. मिसमैच है, तो आपको उसको मिसमैच कराना होगा. जब रेक्टिफिकेशन ऑर्डर आपके पास आ जाएगा तो 2 साल अफसर को तब तक मिलेगा, तब तक वो आपकी एसएससी कर सकता है पूरा विदाउट बॉदरिंग अबाउट लिमिटेशन. सो दिस अमेंडमेंट इन रूल 89 एज वेल. Then there is a rule 96(4). This is risky exports. if you go back to fund provision, we have not done this, refund can be withheld. Export custom से आपने किया, कस्टमर कहते हैं कि ये सुशील वर्मा लॉयर है, बट इसकी एक्सपोर्ट का सब घोटाला है यहाँ पर. They come to this conclusion 3 months after the date of exports. Now they have been given power, they can transfer these cases to the jurisdictional officer of GST department for only one purpose, for verification. And the limitation period shall be applicable from the date when this is transmitted to GST department. जैसे कि 6 महीने के बाद ट्रांसफर करें तो 2 साल आप उसको और मिलेंगे. It's one way of extending limitation of section 54. But this is the rules. I'm sure this rule will be challenged. The act doesn't permit this. That is, they are trying to redefine relevant date. So this kind of notification, I'm sure people will challenge and court will turn it down. There is no power like this for you to do it. But so far this is not challenge. It's not challenge because ultra wide. This is binding. So these are the few important legal amendments which they have done through the 7 notifications. Few of them are accounting part, few are composition, return on borrow. We are not discussing. But the 2 crore thing is a big thing again, because they continue to demolish work of chartered accountants every year, some one way or the other. It's not good. Like I said, reconciliation is a must. तो 2 करोड़ वाले का reconciliation करने वाले जो चोरी नहीं करता है, वो तो ज़्यादा चोरी करते हैं. So whatever logic they have, we don't know. But wrongly availed and utilized, this is a very critical amendment. For 73.6 and 54 refunds, the COVID period has been excluded, so you have to recompute the dates. So अगर भी 17-18 का आज भी आपको अगर रिफंड रहता है, you can safely claim now without any objection from anybody. Right? Subsection 3, section 50, there was a controversy. Now they have notified that interest will be only in cash component. And if you short pay tax or don't pay tax or for any other reason, your tax is found short while filing a return, then notwithstanding what ITC amount you have in the return, interest will be calculated from the date when this became due. So you have to reverse that ITC full amount. So that is a deeming fiction they have created. And then this exports. Input tax credit on services, not retrospective. BKC footstep judgment Supreme Court has been overturned by this amendment. Now you can claim refund, that is refund in cash on input tax credit for services, but after 1st July 22. So all those invoices on which you claim this ITC on services shall be dated post 1st July 22. But the reconciliation is a must whenever you file a refund. Then this is 7310. Erroneously refund, they have to recover. Recovery file issued there also, the COVID limitation has been excluded. Right? So that is wherever there were statutory limitations which were not extended by Supreme Court under Article 142. What was Article 147? Suo motu civil petition. It was for the purpose of filing application, appeals, miscellaneous applications. There were no question of returns or assessments. So now there also, through amendment in the Act itself, they have invoked limitations to give benefit to revenue officer कि अगर आपने नहीं किया तो आप कर दीजिए. So जितने आपके बिजनेस में केस पेंडिंग है, which were to get time barred very soon, now they have 1 more year of life. So now they can go fall donkey and hurry and go after you to give us tax. So these are few amendments which I thought we should discuss. And SEZ supplies. There is one more amendment. It was not written here, but I read it. This e-invoicing, इसके लिए compulsory है?
More than 20. Last 2 years since.
So now, if you are doing e-invoicing, you have to give declaration on your invoice. Okay. I am not under compulsory e-invoicing. What does it mean? It means if you do not do it, you have found you are liable to issue invoices, then they don't have to prove anything else. But this is an act amendment. It's mandatory requirement. You have to mention on your invoice कि I'm outside the invoicing limit. जो भी declaration है वो declare format नहीं है. आपको invoice में mention करना है.
हर किसी के
हाँ, yes.
इसका मतलब ये हुआ ना कि जो भी जिस पे इनवॉइसिंग लागू नहीं है उसको अपने हर इनवॉइस के ऊपर स्टैंप लगानी पड़ेगी।
Stamp लगाओ जो मर्जी लगाओ. You have to tell your clients कि सर ये करना है. If they catch it, this will be violation.
ये तो हर
Section 31 पे जो tax invoice is not correct.
ये तो हर एक को इम्पोर्ट करेगा। और ये 5 जुलाई से एप्लीकेबल है।
Yes.
तो
क्लाइंट को बुलाओ कि बहुत जल्दी ओपिनियन देनी है. 11,000 रुपए का चेक लेकर आना. आपको बताते हैं क्या करना है.
और एक स्टैम्प वेंडर
हैं?
एक स्टैम्प
हाँ, एक स्टैम्प वेंडर और इकट्ठा करें. So normally, I think Suresh is right. If people are not using Tally, Tally में तो आ ही जाएगा ये automatically जो भी software है. But stamp is a better portion, better amendment. So yes, we hereby certify. We are not covered by notification number source or edit source.
जो मैनुअली करते हैं
नहीं हो पैसे भी लगा सकते हैं. But when you give documents to a transporter, you will be hit by 129. जब आप पेपर कैरी करेंगे, पेपर आर नॉट कंप्लीट. So this is another major amendment.
तो आईटीसी क्लेम पे भी कर देंगे वैलिड इनवॉइस नहीं है।
हाँ.
आईटीसी
कह सकते हैं।
कहने को कुछ भी कहेंगे, वो आगे देखें क्या कहेंगे, but yes, invoice is not complete. Obviously,
यस
अगर इनवॉइसिंग सर्विसेज बात हो सर्विस के लिए भी
सर्विस पे ऑल इनवॉइसेस आफ्टर 5th ऑफ जुलाई। और कोई ध्यान नहीं देगा इस पे, कोई ध्यान भी
सब
नहीं
देंगे, जब पकड़ पाएंगे सब ध्यान पाके सब ध्यान देंगे, ध्यान रखता है.
सर नोटिफिकेशन नंबर क्या
ये मुझे नहीं
है?
पता.
14 में
मतलब ये भी कल वो बोलेंगे स्टैम्प के हाथ से लिख के बना दे, इनवॉइस बना दे.
नोटिफिकेशन नंबर 14 में है ये पॉइंट। तो
इसको पकड़ लो ना चाय पर. Don't stand with me, stand with him.
14 में ये वाला पॉइंट
I have no idea.
नोटिफिकेशन आएगा ना कल
कल आएगा ना,
परसों आएगा
ये भी जो नोटिफिकेशन
परसों आएगा।
परसों जो है
Okay, let's continue our topic refunds. We did yesterday section 54. 54 was starting with any person, then you had phrase of registered person, and you also had phrase of taxable person. All three have different consequences. 54 is also applicable to an information of a recipient can also claim refund. It's not necessarily a supplier has to claim refund. That is the meaning of any person in 54(1). The person includes recipients also. And then we said that 54(3) allows refunds in two circumstances in cash. Export of goods or services that are defined in section 61 or inverted duty structure, now including goods and services. Custom कह रहे service नहीं थी. Now we say including goods and services post 1st July 22. And then we came to 54(5) that the proper officer has to determine the amount of refund due to you. So it is not, your application is not sacrosanct that whatever you claim will be given to you. He can modify the application, say based on the verification or due diligence I have done, your refund is likely to be given for this amount. 90% advance refund is also discretionary, it's not mandatory. He may allow 90%. If it doesn't allow, you can't do anything. But he has to give reasons for not giving 90% advance refund to you. Then we came to 54(8). So those are the 6 grounds in which cash refund can be given. So even when you go to any court, the court order will not have any sanctity in terms of this particular law, 54(9), unless it satisfies the 54(8) requirements. So therefore, whenever you challenge an appeal, file an objection against a rejection order, you have to come and plead where your refund is in a particular subsection, subclass of section 54(8). My refund is due to the following reason, and this reason is covered for by subsection 8 of section 54. You have to plead it. Then we read 54(7) with the judgment of Hamdard Bank Union of India. It's a 2020 judgment. All formalities have to be completed within 60 days. In Jan International case of Delhi High Court, the deficiency memo was not issued within the mandatory period of Rule 90, 15 days. They came here, went there, they went twice to High Court, the ultimate case was this High Court. The counsel Rajesh Chan said, if 15 days is a mandatory period. Beyond this they cannot go. the government council took a plea. No, it's late, but unless we should actually remember how we determine refund. Then court interpreting 54/7, read with rule 90, came to the conclusion, if I now allow you to issue deficiency memo, in other words, we are allowing you to extend the limitation under 54/7. That is not permissible. Then the refund with interest, notwithstanding any verification done or not done. So 54/7 is a sacrosanct limitation of 60 days. But 54/7 does not have a deeming provision like this return business, it will be deemed to be revoked. 54/7 doesn't carry a phrase, if the refund is not processed within 60 days, it shall be deemed to have been given. But when we read the Hamdard Dawakana judgment, Union of India Hamdard back flap, you can Google and get a copy, you must read if you are more interested to read more of this. There the section 11BB was similarly placed like we have 54, 54/7 and 56. The only thing was there a period was 90 days, here period is 60 days. There the justice, both judges, Deepak Kumar and Deepak Mishra, some other judge, they went through Supreme Court judgment of ITC and Ranbaxy, where they came to conclusion that these limitations are sacrosanct. Whatever you want to do, you have 60 days period. उसके बाद आप कुछ कर नहीं सकते, आपको रिफंड करना है. जो भी आपने नोटिस इशू करना है, डेफिशिएंसी करना है, रिजेक्शन करना है, जो भी करिए आप 60 दिन में करें. But the judgment fell short to write, so what happens if refund is not given within 60 days? Then they said that this interest will be evoked.
Just like Shanti Kiran, what is the bad act?
Shanti Kiran is not relevant. Shanti Kiran bogus billing. We are not talking billing.
Limitation because of 15 days notice.
Even principle does not apply here. We are talking about interest. We are not talking about tax liability. So interest is automatic. That is अगर 60 दिन में आपका रिफंड और आपका सपोजिंग 60 दिन में आपका ऑर्डर से रिजेक्ट करते 60 दिन के बाद यू गो टू अपील यू विन टेक द रेड कार्ड you will get full interest. This the effect on Supreme Court of that plan. So अगर 60 दिन में आपको डेफिशिएंसी मेमो नहीं RFD 03 नहीं आता 15 दिन में immediately put a letter proper option or you cannot issue in view of Gyan International Delhi High Court judgment. Take money. Put him on notice. Deputy Commissioner. If it can be done online, put it online. Sir, we filed the fund application on 1st January. You issued RFD 02 on 7th January. You were supposed to send me a deficiency memo on RFD 0 by 22nd May. Whatever 15 दिन जब भी होते हैं. You have not given now, therefore you are debarred from issuing RFD 03. But doesn't mean that he cannot issue to RFD 08. Showcase notice they can still issue. Some people ask me कि deficiency के बिना showcase कैसे हो सकता है? No, it's not necessary. Showcase notice can be issued. He find your application in order, but now he wants to verify this thing. He is not happy with your 8 documents filed by you. Verification you can verify. Now including risky exports you can verify. But deficiency memo I cannot issue. So Gyan International judgment was only restricted to late issuance of deficiency memo. It did not have any issue regarding showcase notice, etc. So RFD 0 can still be issued. But whenever you get refund based on your application, 60 days period and after that interest is that much. After interest मिलना. Right? Let's come to 5th. And the circular 124? Yeah, 124. 124 is a big circular by board which is binding on the officers. Any circular that is beneficial to you or your client, it is binding on the officer. He cannot avoid giving effect to the circular under no circumstances. But this interpretation placed by Revenue Department, he cannot say मैं कमीशन से agree नहीं करता. So जहाँ 15 दिन में आपको deficiency में issue नहीं, immediately put a letter to proper officer. Now you cannot issue, and the interest matter has already started. Put him under pressure, he can do nothing. The Delhi High Court judgment, if he commits contempt, he will be hauled up. उसको लिखो कि Delhi High Court judgment is binding upon you.
RFD 02 की रिपोर्ट जब तक वो satisfy नहीं होते, जब तक क्योंकि RFD 02 के बाद ही कोई ये लाइन टाइमलाइन शुरू होती है.
फिर 60 दिन में
Acknowledgement
नहीं, आप उसकी कितनी acknowledgement आ रही है? 3 दिन क्या लाखों
लिमिटेशन ही है. 15 की कोई लिमिट है. मेरे ख्याल में 15 दिन
02 और 03 मतलब मैं तो 02 आएगा या 03 आएगा
02 15 दिन नहीं होता.
Acknowledgement तो दोनों 15 दिन ना, ठीक है ना? 15 दिन के अंदर
deficiency देनी है.
15 में एडमिशन देनी है ना, ना दे।
तो 16 दिन के बाद तो
No, no, his point is जब मेरे को RFP थ्रू होती है नहीं, बाद में application not taken on refund and not 15 days, right? Again put him on record. Wherever you want to hold him responsible, if you find there is no limitation, put him on record. कि सर 54/7 में 60 दिन है, 30 दिन आपने ले लिए, आपका एडिशनल कमिश्नर वापस से बेंच बना के क्या डिस्कशन करते हो हमें नहीं पता. Put him on record, right? Let's read 56. Interest. Go back to 54(5) first. If on receipt of any such application the proper is satisfied that the whole or part of the amount claimed as refund is refundable, he may make an order accordingly and the amount so determined shall be credited to etc. etc. 57. And if it is 58 reason, we can give cash refund. Right? Now 56. If any tax order to be refunded subsection 554 to any applicant is not refunded, is no within 60 days from date of receipt of application subsection 1 of that section, interest at such rate not exceeding 60% as the case may be, 6% as the case may be, notification issued by government recommended council shall be payable. There is no discretion left with the officer. Like income tax, he has to include interest along with the refund. If he doesn't, he is violating section 56. अगर आपको रिफंड आता है जो 60 दिन के बाद दिया गया है, immediately write a letter to the proper officer, copy to the concerned commissioner. Yes, reason you were supposed to give interest, you have not given. We shall claim compensation on this also. Put him on record, so that tomorrow when you go to court, you say what action did you take? They said हमको interest से दार कर रहे थे, no, it's also your duty. You let the officer know that you have violated the law. Therefore, not only Circular 124, this is also mandate of the law. In Circular 124 also, they have quoted section 56(1). I have read it, so I know this law. From the date immediately after the expiry of 60 days from the date of receipt of application till the date of refund of such tax, the refund is given to you on the date when it comes into your bank, not when refund voucher or refund order is issued. If the account people जो आते करते हैं दिल्ली वाले account वाले देखेंगे वो देखेंगे, there is nothing like this in the book or rules. It is their internal rules which are not binding upon us. तो अगर रिफंड ऑर्डर 1 जनवरी का था और आपकी पेमेंट 1 3 को आती है, तो डेट ऑफ रिफंड टू यू इज 1st March not 1st January. So in 1st March 60 days are expired. So in the intervening period you are liable to receive interest. आपको चिट्ठी लिखनी है जब भी आपका रिफंड लेट होता है, आपने हमें 56(1) में इंटरेस्ट देना था, आपने नहीं दिया, therefore please issue us interest voucher or whatever the amount or we take legal action. सर्कुलर जो भी सर्कुलर को कोट करना आपने, हम 10 बैग की जजमेंट लगा सकते हैं, दिल्ली हाई कोर्ट जजमेंट लगा सकते हैं, बहुत जजमेंट आप इसके ऊपर सारे हाई कोर्ट्स की हैं, लेकिन आपको ये काम करना है. डोंट लीव इंटरेस्ट फॉर योर क्लाइंट, इट्स योर जॉब. इवन इफ इट्स 200 rupees, डोंट लीव इट. It helps you to learn more. It helps you to draft better applications. Keep putting back, telling it, don't go, we're going to high court. Or to commissioner. See, all these officers, proper officers are who? They are appointed by commissioner. They work under delegated legislation. Who the delegator? Commissioner. Or the government or the board, whoever it is. You have to copy to them. Receipt लेकर आओ उसकी, sample लगा. जब कोर्ट में जाओगे, कोर्ट will hear nothing. Then you are put to notice. What explanation now? What? Right? So don't leave interest at any cost.
सर, इसमें टाइम पीरियड है कि तब तक हमें कोई बोलना है कि हमें इंटरेस्ट नहीं मिला.
Immediately 60 दिन के बाद जाते रिफंड आता है, आपको 15 दिन लेट दिया, 15 दिन का इंटरेस्ट मांगो.
कब तक हमें दोबारा रिमाइंड करने के इंटरेस्ट हमें नहीं मिला, तो उसमें कोई टाइम
No, there is no limitation.
बैंक में कोई लिमिट नहीं दिया.
इंटरेस्ट आपको ये तभी तक देंगी जब तक आपके बैंक में गया.
हम कितने टाइम को
नेक्स्ट डे, सेम डे.
टाइम लिमिट तो कुछ नहीं है.
No, there is no, there is no. Nothing.
एक्चुअली रिफंड ਜਿਹੜੇ ਆਏ ਚੈੱਕ ਕਰਦੇ ਆ
हाँ.
लेट से नहीं
पैसे बनाओ, yes. Interest can be claimed. Then there is a proviso. Provided that where any claim of refund arises from an order passed by an adjudicating authority or appellate authority, go to section 2, who is an adjudicating authority. There is a point of law here also we will discuss. Subsection 4. Adjudicating authority means any authority appointed or authorized to pass any order or decision under this act, but it does not include the board, the revisional authority, the authority for advance ruling, the appellate authority for advance ruling, the appellate authority, the appellate tribunal, and the authority referred to in subsection 2 of section 171. Go to 171 2. The central government on recommendation council of notification consider authority and power so and so. So अगर ये adjudicating authority ये हैं तब 56 जो proviso लागू होता है. So this word is defined. So you have to first realize that what you are doing is this officer an adjudicating authority. Now come to another word here. Appellate authority. Adjudicating authority is not an appellate authority. Appellate authority is separately defined. Appellate authority means authority appointed or authorized to hear appeals referred to in section 107. So whatever we say that both are not interchangeable phrases. They are separately defined in the act, therefore the treatment is totally separate. Appellate authority is only section 107. If there is a tribunal, they have defined tribunal also. Right? Yeah. So provided that where any claim or refund arises from an order passed by an adjudicating authority or appellate authority or appellate tribunal or court which has attained finality and the same is not refunded within 60 days from date of receipt of application filed consequent to such an order, interest such rate shall not exceed not in 95 as may be notified by the government or so and so shall be payable in respect of such refund from the date immediately after expiry 60 days from the date of receipt of application till the date. Now supposing you win a case under section 107 कि भी आपका रिफंड बनता है, राइट? आप उसने रिफंड को क्वांटिफाई कर दिया कि आपका 10 करोड़ रुपए रिफंड बनता है, रिफंड आपको नहीं मिलेगा जब तक एप्लीकेशन मूव नहीं करेंगे. Now there are two refunds, two interests. One is 60 days and above. So another is 60 days after date of the order. Now here is a debate कि मेरा 10 करोड़ का रिफंड हुआ, रिजेक्ट कर दिया गया, ठीक है, जो मुझको मिलना है, और वो रिफंड एक्सेप्ट हो गया. लेट अस से उसको 1.5 साल लगा अपील होने में. अब जो पहला कहते हैं कि अगर 60 दिन के बाद आपको रिफंड देते आपको इंटरेस्ट देना, but there is a proviso and an exception with the main provision. He says अगर कोई appellate authority आपको रिफंड देती है, उसके ऑर्डर कम्युनिकेशन के बाद आप एप्लीकेशन मूव करते हैं, तो अगर आप 20 दिन एप्लीकेशन में लगाते हैं उसका इंटरेस्ट आपको नहीं मिलेगा. अगर एप्लीकेशन देने के बाद अगर 60 दिन में आपको इंटरेस्ट नहीं रिफंड नहीं मिलता तो आपको इंटरेस्ट मिलेगा. सो बोथ substantive provision and proviso stand on different footings. 56(1) is not related to adjudicating authority, appellate authority, tribunal or court. वहां तो कोई झगड़ा था, अपने झगड़ा खत्म हो गया. But where you have claimed a refund and refund is given after 60 days for whatever reason, it will relate back to the 60 days from date of application. But only when pursuant to an order you get a proviso. So these two, they seem to be creating a conflict, but there is no conflict. Harmonious consumption rule is very clear. कि अगर proviso का मतलब ये होता है फिर तो सारे रिफंड चेक कर देंगे आपके, 2 साल कोर्ट में ले जाएंगे आपको, आप बोलेंगे 7 दिन में रिफंड ले ले, हमने तो आपका रिफंड 7 दिन में दे दिया. So that cannot be an interpretation placed. This will make the statute unworkable. So the 56(1) stands on a different footing, and the proviso of 56(1) stand on a different footing.
When we say that after rejection, if it is allowed, it will relate back to the original.
It has to relate back.
It has to relate. Then what is the consequence of this proviso?
This proviso is कि आपने बोला कि आटे 5% है, वो कहते 10%.
That means if there is a list or dispute regarding any particular fact.
Yes. That
Not
is-
vis-a-vis to the
not
refund.
vis-a-vis your refund application.
Right.
उसमें कोई डाउट नहीं था. अभी उसने किसी रीजन में किया. My question is, supposing the proviso included this also, this can never be legislative intent, because all revenue officers will reject all your big refund applications. और कमिश्नर ऑफ अथॉरिटी बोलेगा 3 साल तक इनको डेट नहीं देनी, भाई घुमा दो इनकी, आप मैं रिटायर हो जाऊंगा तब आप देना इंटरेस्ट. So that cannot be intention, right?
इसमें जो मुझे लग रहा है कि प्रोवाइडो उस एफिलिएटेड सेक्शन 129 और 130 का हम रिफंड लेके आते हैं जब कोई गाड़ी पकड़ी जाती है, तो मुझे लगता है प्रोवाइडो जब लगेगा क्योंकि हम यहाँ क्योंकि वो 50
I'm saying it can be for any reason. It can be 73, 74, 75 assessments, 129, 130, किसी भी रीजन से हो, right? कोई आपका क्लेम था जो रिजेक्ट किया गया, right? सपोजिंग आपके 10 करोड़ के क्लेम थे, उसमें 2 करोड़ के रिजेक्ट किए गए, तो आपका रिफंड भी 2 करोड़ से कम कर दिया गया, ठीक है? दैट इज से उसने सारा रिफंड रिजेक्ट कर दिया आपका, और एक ही सही से. अगर हम एक क्यों लेते हैं कि अगर अपने अथॉरिटी का ऑर्डर 2 साल के बाद हुआ, कैन बी से कि ये आप अप्लाई करूंगा 10 दिन के बाद तो 60 दिन में दे दे मुझे कोई इंटरेस्ट नहीं मिलेगा, ये तो पॉसिबल नहीं, राइट? So this would be one of the reasons where you practice court etc. and the money is allowed to
Mostly
be
this will be
fined.
assessment related cases. Mostly this will be assessment related cases where your assessment.
Slowly we will let the law evolve. तो क्या करते हैं? But so far they are doing this only. हम तो आपको इंटरेस्ट प्रोवाइडर के हिसाब से देंगे.
सर तो ये 6+9 कैसे दें इसको?
Hmm?
6+9 की वो 6% वो वाला मिलेगा और 9%.
Not a sitting 9%, they have to notify.
9%.
But Gujarat Bombay High Court gave 9% based on this only. But matter pending है Supreme Court में, हुआ नहीं अभी.
9% is subject.
Explanation. Read explanation, maybe you get more clarity now. For the purposes of this section, that is only 56, where any order of refund is made by an appellate authority, tribunal court, or court against an order of proper officer under subsection 55, the order passed by an authority, appellate court shall be deemed to be an order passed under subsection 5. Now you are clear? The refund shall relate back to 54(5). 54 में से 2 करोड़ का आपका रिफंड रिजेक्ट कर दिया, उन्होंने एक्सेप्ट कर लिया, so this will be डेट ऑफ 54(5). तो अगर आपका रिफंड 60 दिन के बाद दिया गया तो आपको इंटरेस्ट मिलेगा. That is the function of 54(1), substantive provision. A proviso creates an exception. कितने भी रीजन हो सकते हैं, 5 के ऑर्डर को अगर आपको एक्सेप्ट किया जाता है, इट विल ऑलवेज रिलेट बैक. तो आपको 60 दिन के बाद ब्याज मिलना है. दिस इज द implication of section 56. We come to 75. When finish 75, then come 0107. 75 is जरूरी है. So remember 73, 74, same grounds except 74 deals with fraud, suppression of facts, etc. And suppression of facts is defined in section 74 explanation, which is applicable to both 73 and 74. दो लिमिटेशन है, 3 महीने पहले नोटिस और 6 महीने पहले नोटिस, 3 साल और 5 साल for date of annual return. Forget 17, 18 is only a particular year where COVID period to be excluded. And these are the only reasons, 4 reasons mentioned in 70-74, which create jurisdiction with the proper officer to invoke 70-74. There can be no other ground because it says only on the following grounds. Right? अगर वो 3 महीने का नोटिस नहीं देता, 6 महीने का नोटिस नहीं देता बिफोर दी और एक्सपायरी ऑफ 5 or 3 years, और इसमें ऑर्डर पास नहीं करता, then the proceeding comes to an end. It's all over for him. Right? So the explanation was different from the service tax or customs, where suppression of facts were defined. Right? So you have to be very careful before you apply any judgment of Supreme Court, whether this is the case of suppression of facts. जहाँ आपने रिटर्न नहीं भरी, आपने कोई इन्फॉर्मेशन नहीं दी, आपने कोई डॉक्यूमेंट नहीं दिया, आपने स्टेटमेंट नहीं दी, दिस कैन बी डीम्ड टू बी, आपको सेक्शन 70 के समान आते हैं. You just take out to tender statement and produce books of accounts. If you don't, suppress your facts. Read explanation now once more before we proceed further. Explanation 2. For the purposes of this act, not for 73-74, suppression shall mean non-declaration of facts or information which a taxable person is required to declare in the return, etc., etc. So the explanation 2 is not for 73 or 74 for the purpose of this act. So section 70 is also part of the act. So once you get summons, there's a tender statement, give information, file return or whatever. If you don't do it in time, it is suppression of facts. But this can be serious consequences. कहते हैं someone everywhere चले जाएंगे, चिट्ठी भेजते हैं बीमार है 2, 3, 4 बारी, that is you are in trouble. So summons you should never avoid. Whatever information asked for, you must get. Whatever may be the consequences for your client, but once summons are issued in section 70, it's a judicial proceeding. If it's summons you don't give information, you tell a lie, it's a 7 years non-bailable imprisonment under Indian Penal Code. Because this is deemed to be a judicial proceeding. कोर्ट में जाकर प्रूफ नहीं बोल सकते, कोर्ट के ऑर्डर्स को आप डिफाई नहीं कर सकते. That is why to put pressure on you, they don't send you notice, they send you straight away summon under section 70, ऑर्डर वैसे देके जाओ हमारे. So be careful whenever we get section 70. We come to 75. 13 subsection है, 13 important है इसमें. They give effect to 73, 74. Where the service of notice or issuance of order is stayed by an order of a court. Service of notice or issuance of an order, not order, issuance of an order is stayed by an order of a court or appellate tribunal. The period of such stay shall be excluded in computing the period specified in 70-74. I tell you, we got a show cause notice under 16(4) in Hyderabad. I will report this matter in our group also. कि जी आपका 73 करोड़ की डिमांड है क्योंकि आपने रिटर्न लेट भरी थी 64 में आईटीसी जो भी आपने किया. हमने कहा था हमारे तो सप्लाई ने रिटर्न नहीं दिए, हमने 75 करोड़ रुपए कहाँ से देने थे, वे कहाँ गए. पर फाइल इट इन तेलंगाना हाईकोर्ट स्टेट दी नोटिस. व्हाट द इफेक्ट था 2 सालों में. अगर वो 10 साल भी स्टे रहे, अगर वो विद इन लिमिटेशन ऑफ 74 में मेरे को नोटिस दिया गया था, that is 3 months before the expiry of 5 years from date of filing annual return, so this period now shall be excluded. 5 साल के बाद हाईकोर्ट डिसीजन कहता है ये नोटिस ठीक था, राइट. उसके बाद जो 5 साल का पीरियड बचा है, जो पीरियड बचा है, that can still be continued. This is first meaning of 75(1). It's only what is state, service of a notice or issuance of an order is state. हमारे केस में था नो ऑर्डर शैल बी पास टिल द डिसीजन ऑफ हाई कोर्ट. तो जितना पीरियड उसमें लगेगा, दिस पीरियड शैल स्टैंड एक्सक्लूडेड फॉर द पर्पस ऑफ कंप्यूटेशन ऑफ लिमिटेशन अंडर 73, 74. Where an appellate authority, there is no adjudicating authority word here. Read carefully. Subsection 2 is where an appellate authority or appellate tribunal or court concludes that notice under subsection 1 is not sustainable for the reason that the charges of fraud or any willful misstatement suppression of fact to evade tax has not been established against the person to whom the notice was issued, the proper officer shall determine tax payable by such person, deeming as if the notice was issued in subsection 73. 73 cannot be converted to 74 automatically. Subsection 2 deals with conversion of 74 into 73 automatically. आपके वहाँ नोटिस आया, like JP's का जो 74 के आपको फ्रॉड हो, misstatement of suppression of fact हो, and you establish before the court के लिए हमारा पूछे मन हमने रिटर्ने भरी है, हमारे सब यूजरों का नाम है, हमने सारी पेमेंट्स की है, ये है ब्ला 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 ब्ला, एंड दिस वाज प्रेशर ऑफ फैक्ट जब भी हमारे से मांगा हमने सब कुछ दिया. नो कोर्ट कम्स टू कंक्लूजन के 74 आपका केस नहीं करता. कोर्ट फैशंस दैट नोटिस. नाउ द ऑफिसर कैन प्रोसीड इन 73. So what you have to see in 73 first, is the limitation available? Limitation not available, there is no exclusion. Exclusion was only 73(1). where an issuance of order or issuance of notice or issuance of order is state. वहाँ exclusion है, subsection 2 में कोई exclusion नहीं, right? तो अगर 74 को उसको 73 में कन्वर्ट करना है, आपको देखना है कि 73 की लिमिटेशन from date of notice by him is it still available, right? हमारा एक इशू बनेगा कि 74 में उसको 6 महीने पहले नोटिस देना, 3 महीने पहले. So if he has a limitation, he can still do it. If it is not a limitation, board limitation, he can't follow, then you put him notice, it's time back, it's all over. You can't do it. But don't reply कि सर वो लिखा है 73 में आ गए, तो आप उसको बोलना है भी 73 में आ गए, उसके कंसीडरेशन अलग है, लिमिटेशन अलग है। लिमिटेशन डिस्कस करते हैं पहले, आपको भी लिमिटेशन है कि 2 लिमिटेशन है? क्या आपको 3 साल से पहले 3 महीने पहले मेरे को नोटिस देना था और 3 साल में ऑर्डर पास करना था? तो दोनों खत्म हो गई, बात खत्म हो गई, साल हो गया, the notice has to be dropped. He has no choice but to drop the notice. Because the only thing he could have done is 74 invoke कर सकता है. Since there is no order, section 108 giving power to commissioner to so revise, that is also not possible. So these proceedings have to come to an end immediately. 70, these are very important sections in law. Subsection 3, where an order is required to be passed in pursuance of a direction of the appellate authority or court, such order shall be issued within 2 years. अगर कोई हाई कोर्ट ट्रिब्यूनल केस डिमांड करता है तो 2 साल के अंदर प्रोक्टर को ऑर्डर पास करना है फ्रॉम डेट ऑफ कम्युनिकेशन. कम्युनिकेशन इज व्हेन इट पुट ऑन पोर्टल. 2 साल में नहीं करता है, टाइम बार्ड इज फिनिश्ड. 2 साल के बाद आपको नहीं जाना उसके पास. वो जो पुट इन रिप्लाई कि सर रीड 75 सबसेक्शन 3, order of date is 1st January 20. You want to do by 31st December 22. You are doing in February. It's all over. Thank you so much. Refund the money. Now refund will be applicable under 54. But if you have deposited everything, पैसा आपको रिफंड मिलेगा. आप उसको आपको रिफंड अप्लाई करना है. जब रिफंड करोगे तो 7 दिन के अंदर उसको आपको पैसे देंगे. So the Amit, that 56 proviso is applicable now. Where your appeal is deemed to be time bar, right? Remand और time bar, आपने पैसे जमा कराए, तो आप रिफंड के अप्लाई करो. 7 दिन में नहीं देता तो आपको 56 में ब्याज देंगे, right? This is one of the circumstances. 4, an opportunity of hearing shall be granted where a request is received in writing from the person charged with tax penalty wherein is first section. जहां आपको टैक्स पेनल्टी का नोटिस आता है, आपको लिखना है पर्सनली आई वांट टू बी हर्ड पर्सन. Only then notice hearing is mandatory. But then is followed by comma and word or. Or means अगर उसने आपके खिलाफ कोई और एक्शन लेना है तो आपको उसको नोटिस देना है. वो मैंडेटरी. यहाँ आपको लिखने की जरूरत नहीं है. But only when you get a notice for tax penalty, interest penalty, whatever, then you have to say we have seen your notice. We are closing all the documents. However, we want to be heard personally. Underline कर दो उसको. Then if he doesn't give you opportunity, the order is bad in law. But और वर्ड के आगे लिखा है कि अगर उसको कोई और आपके खिलाफ एक्शन लेना है, in that case, he has to give you opportunity being heard. Adjournment 3, I think this is directory, कोई mandatory चीज नहीं है. Now supposing you get a notice in 73 or 74, demand has to be quantified. उसमें लिखा है 10 करोड़ की आपकी डिमांड है, इंटरेस्ट टैक्स पेनल्टी. Order cannot create demand more than 10 crores. And there is no provision for issuing a second shogun notice. कोर्ट कहते हैं दे सकते हैं पर इसमें कोई प्रोविजन नहीं. तो अगर 10 करोड़ का आपका नोटिस था, his order cannot be 10 crore 1. It has to be up to 10 crore. That is the meaning of 74.6. Subsection 8. आपने अपील की 10 करोड़ इंक्लूडिंग इंटरेस्ट टैक्स एंड पेनल्टी. टैक्स उन्होंने आपका 4 करोड़ कर दिया, उसी प्रोपोर्शन में इंटरेस्ट पेनल्टी रिड्यूस ऑटोमेटिक. इस ऑटोमेटिक रिडक्शन तो जो भी आप ऑफर करना आपका जमा करानी है, यू कैन कैलकुलेट योरसेल्फ इन डिपॉजिट. बट देयर इज नो रिक्वायरमेंट कि ऑफिसर विल पास द ऑर्डर टू दैट इफेक्ट. Interest on tax short paid or not paid, there is no waiver of interest. Not even Supreme Court or not even President of India can waive the interest. जहाँ आपने short pay tax किया और नहीं किया है, interest आपको देना है notwithstanding that is mentioned in the order.
This provision was there from right from first.
No. कहीं नहीं है. Interpretation 27 में कहाँ लिखा है दिल्ली के टैक्स में? 42 में कहाँ लिखा है? ना. This language is
Charging of interest automatic.
कहाँ लिखा है? हम कहते हैं है सुप्रीम कोर्ट कहता है
कोर्ट इन धीर सर आनंद वर्सेस स्टेट ऑफ जेड के क्लियर कट
उनके प्रोविजन है। ये ऐसा प्रोविजन नहीं है कि आपको
there
देना ही
also
देना है।
there also section 8 3 8 1 2 and 3 interest was chargeable as it was chargeable in the VAT also, but they determined that it is automatic.
What I
it
am
can't
saying
be.
is that this provision was not there, interpretation was always this, but now they have mentioned this provision right in the act. मतलब we lawyers don't debate. So if it is found by the officer that you did not pay tax or you short paid, आपको interest उस डेट से देना है। इसीलिए वो amendment की गई है, interest आपको तब से देना है जब आपका tax due था।
बिल्कुल।
If you follow JK synthetics, this goes counter to this. JK synthetics didn't say that you have paid tax for interest from the return. Asset Simon ने बोला था, JK synthetics ने नहीं बोला था। Look at Maruti wire. The taxable turnover was not included in the return. They say interest is not payable, right? So you cannot say that this provision never existed in any law. दो latest judgment है सुप्रीम कोर्ट की और VAT में ही है। So now they have paid कि कुछ भी आपको लिखा नहीं लिखा आपको देना है, बात खत्म। So they have made it more specific so that we lawyers don't start debating in courts.
Debatable on the state.
Yes.
No further litigation.
Yes. 7510, a very, very important subsection. The adjudication proceedings shall be deemed to be concluded if the order is not issued within 3 years as provided for subsection 10 of 73 or within 5 years 7410. तो अगर 75(2) में 74 का 73 में कन्वर्ट करते हैं और वो 3 साल बेच चुके हैं, everything is over. But you still have to write to him. Because if he passes the order, you still have to go to litigation. Even if he passes an illegal order, if he passes the order without jurisdiction, time barred, still some court has to question it. You can't say कि we don't pay. तो अगर आपको लगता है admission नहीं है, put him to notice that ये time barred है, please don't proceed further. And never ever in your life sign a backdated order to help an officer. तो सोर्ट रिवीजन की लिमिटेशन बहुत ज्यादा है। Supposing 3 साल 2 महीने हो गए, बट साहब आप हमारे पुराने हैं सर, मर जाएंगे हम आपके सारा रिलीफ दे देते हैं, आप 3 महीने पहले ऑर्डर साइन कर दो, आपने कर दिया, तो आपने अपने क्लाइंट को धकेल दिया मौत के मुंह। The now commissioner can so much revise that order. He has limitation. So never ever sign an anti-dated order sheet in your whole life. Never ever do it. It's time bad. It's time bad. We are lawyers, professionals. हमें किसी की हेल्प नहीं करनी। करते हैं हम लोग। सर आपका रिफंड भी दे दूंगा सर। वो खुद ही लिख रहा है कि मिनिस्टर को ये मैंने क्या ऑर्डर से रिवाइज कर। Then what will you do? Can you say मैंने एंटिटी साइन किया था? You can't. Therefore, keep the limitation of 108. Section 108 deals with summary revision. We will do it today before you proceed to sign backdated order sheet. 11. Now this is also a huge provision. बहुत बड़ा provision है. हालांकि आज तक कभी इसको लागू नहीं किया गया. ये provision कहता है कि मिस्टर ए के केस में किसी अपीलेट अथॉरिटी या ट्रिब्यूनल ने बोला या हाईकोर्ट ने बोला कि अभी ये चीज टैक्स एग्जम्प्ट है, राइट? डिपार्टमेंट ने अपीलेट अथॉरिटी की या ट्रिब्यूनल की या हाईकोर्ट के आगे अपीलें कर दी, ट्रिब्यूनल में, हाईकोर्ट में, सुप्रीम कोर्ट में, किसी और केस में, इस केस में नहीं, किसी और केस में, और पहले वाले ऑर्डर को इफेक्ट नहीं दिया, आपको रिफंड नहीं दिया, कुछ भी किया, कोई भी नहीं किया। अब वो कहते हैं कि जितना पीरियड उस केस को डिसाइड करने में लगेगा, दैट शैल बी एक्सक्लूडेड। वेरी स्टूपिड प्रोविजन, लेकिन आप हर एक्ट में है एज प्रोविजन। लेट्स रीड इट नाउ। An issue on which the appellate authority or tribunal or high court has given decision which is prejudicial to the interest of revenue in some other proceedings, and an appeal to appellate tribunal, high court or supreme court against the decision of appellate tribunal or the court is pending, the period spent between the date of the decision of the appellate authority, tribunal, or date of decision of the tribunal and that of high court or supreme court shall be excluded in computing the period rapport to 7310, 7410. Unending limitation. हैरान हो गए तुम? अरे ये पढ़ा था, ये वैट में भी है, वैट एक्ट में भी है, कभी लागू नहीं किया। but here they will. तो अगर वो 73 अगर तो 73 टाइम बार हो गया तो अब तो इसका कोई लेना देना नहीं, because no court can extend the limitation. लेकिन 73 4 10 में 3 साल में अभी 15 दिन रहते हैं और ये कुछ ऐसा कर देते हैं किसी और केस में, then they can stay the proceedings, commission can pass the order, we have challenged it, we will wait for the order. उसके बाद उनको 15 दिन और मिलेंगे। तो अगर 5 साल वो केस सुप्रीम कोर्ट में चला, मेरे ख्याल कभी वापस ही नहीं आएगा वो, तो उसके बाद उनको 15 दिन मिलेंगे। दिस इज पर्पस ऑफ 7511। So 75 30 subsections all are operating on a different pedestal. सबकी अपनी इंपॉर्टेंस है for the purpose of 73 and 74 and 56 and 54.
सर
बोलते रहो।
तो केस डिस्क्लोजर हो सकता है सर, केस मैंने कोई फाइल किया एप्लीकेशन कुछ भी, वो केस डिस्क्लोजर उन्होंने
इसी केस में
मेरे केस में होना चाहिए
ना, आप किसी और के केस में, इन सम अदर प्रोसीडिंग्स
ना, जो बोलते हैं
ऑन द सेम इशू।
अदरसी कोई हो सकता है।
हाँ, कोई भी हो सकता है, अगर है तो कोई, नहीं है तो नहीं है, फिर तो बैठेंगे। 7012
सर इस केस में जिसका अपील, जिसका केस है, उसको कैसे पता लगेगा किसी और केस में फाइल, मतलब उसके लिए कुछ कम्युनिकेशन होगा या
नोटिस आएगा
वो नोटिस दे देंगे ना उसको।
कि दिस लिमिटेशन इज नॉट एप्लीकेबल। सपोजिंग आप जाते हो 73 10 के बाद कि ये तो टाइम बार हो गया अभी, कहते नहीं टाइम बार नहीं हुआ, इट हैज बीन एक्सटेंडेड, तो हमने फाइल देना चाहिए। हम क्रिमिनल लॉ सुनते हैं ना, हमने अपील फाइल की, राइट, लेकिन देयर इज नो वर्ड स्टे कि द ऑर्डर वाज स्टेड। तो ऐसे प्रोविजंस बड़े अलग से हैं, इनमें कुछ स्टे का वर्ड है ही नहीं कि द डिसीजन इन योर केस वाज स्टेड बाय कोर्ट, ऐसा कुछ नहीं, सिर्फ प्रोसीडिंग पेंडिंग है, हमने अपील फाइल कर दी, अपील कोर्ट का डिसीजन ट्रिब्यूनल में कर दिया, ट्रिब्यूनल का हाई कोर्ट में कर दिया, हाई कोर्ट का सुप्रीम कोर्ट में कर दिया। तो जितना टाइम उनको डिसीजन होने में लगेगा वो 73 10 और 74 की लिमिटेशन उसको बाहर निकाल देंगे।
हमारा 2A2B वाला केस सुप्रीम कोर्ट में
पढ़ा नहीं पढ़ा?
अभी पड़ा।
Now comes 12. Notwithstanding anything contained in 73 74. So 73 74 will have no relevance for the purpose of subsection 12 of section 75. Where any amount of self-assessed tax in accordance with the return furnished by under section 39 remains unpaid, either wholly or partly, or amount of interest from tax amendment, the same shall be recovered under the provisions of section 79. What is 79? We will not read this. It's a recovery of tax. We can attach, whatever we want to do. Right? Now, what is self-assessed? Because a valid return is filed only under section 39. Other returns are not part of section 39. Commission can ask you to return file करके ले आओ, बना के लाओ. Information law, that is not a return. Return is filed only under section 39. अगर आपने सेल्फ असेस्ड पे नहीं दिया तो इंटरेस्ट आपको देना है, कोई भी अमाउंट आपके पास नहीं। And if you don't pay, it can be recovered under section 79. So this is section 75. That's that key.
अभी वही दिया था।
तो अच्छा तेरे एलिमेंट वो लावा नहीं होंगे, कोई फायदा आते हैं नहीं होगा। तुमने कभी आज तक कोई टाइम पे अपना प्रोग्राम कंप्लीट किया?
मैं वही गया था।
Okay. Let's start to 107. So before we come to 107, what all we have done in last 9 days? We have done around 104 definitions out of 160. There's still 50 left. We will do it. We have done charging section 9 in detail. We have done section 7 and schedule 1, 2, 3. We have done that. We have done section 15 evaluation. We have done section 16, 17 input test credit. Right? And we have done all those various assessments, whatever they are. We have done 73, 74, 54 refund. We have done 56 dealing with interest. And we have done section 23, 23, 22, 23, 24, 25. We have done 29, 30, cancellation, revocation. Right? So all these main things we have done. We have touched section 67, such as, see that, essentials I have told you. बाकी सारे मशीनरी प्रोविजन है, you can always read yourself. We need not waste time of the class on these issues. We have not done 122, 129, 130. So they deal with penalties. We will do after appeals. They'll be more relevant once we learn the appeal part. So this, within this background, you have to move. Okay, now you have to learn how to draft an appeal. There is no objection here. Like that, there is no objection. This is proper appeal. There is a difference between objection and appeal. Objection is deemed to be, in VAT laws, in Daily VAT Act, continuation of assessment proceedings. So the powers of OHA and the assessing officers are codominous. Whatever assessing officer could do, OHA can also do. Whereas appellate authority power is restricted to the grounds of appeal or the ground raised in assessment order. He cannot travel beyond that. If he has to travel beyond that, he has to give you a notice. If you have been under assessed, and for these reasons, I need to tax you more. Under certain provisions, there are such powers in the Act where appellate authority can also levy tax or penalty or interest for the first time, which is not done by assessing officer. So once you come into appellate jurisdiction, the principles totally change. What we have learnt is academics. Now you have to show your applied knowledge in appeals. So what have you learned? Let us say I tell you, we have finalized the notices. After appeals, we'll send you 8 or 10 orders I have drafted. What I tell you, you get an ex parte order. We call you for notices, so and so जो भी notice number होते हैं उनको बुलाया, आप नहीं आए, आपके order आप नहीं आए, and we think you are doing taxable supply of taxable goods, and therefore you are assessed for 10 lakh rupees. ठीक है, एक तो प्रोविजन है कि आपको within 30 days अगर आप रिटर्न फाइल कर देते हैं, वो order is deemed to have gone 61, 62, तो order खत्म हो जाती है automatically. Supposing 30 days time is over, now you have to go through appeal proceeding. अगर अपील का टाइम है तो, अगर आपका 1/1/2022 को ऑर्डर आपके पोर्टल पे आ गया, अगर रिटर्न फाइल करने का टाइम 30 दिन था, तो 30 जनवरी तक आप रिटर्न फाइल कर सकते थे, एंड दिस ऑर्डर विल बी डीम्ड टू हैव बीन विथड्रॉन इफ यू फाइल अ करेक्ट रिटर्न एंड पे टैक्सेस. You don't do. You file return in section 39, that is valid return. Whenever you file a return, the officer can scrutinize the return is correct or not. If it's not, the order sustains. अब आपको अपील फाइल करनी है, तो 30 दिन तो आपके खत्म हो गए फ्रॉम डेट ऑफ ऑर्डर. अब आपको 2 महीने हुए और 1 महीना आपके पास कंडोनेशन है. Wherever maximum period of condonation is mandated in a statute, no court can give you period more than that, not even Supreme Court, under any circumstances except Article 142 जो कोविड वाले केस में था. तो दैट इज अगर आपका 1/1/22 का ऑर्डर था, तो आपके पास मैक्सिमम टाइम इंक्लूडिंग कंडोनेशन इज 30 अप्रैल. 30 अप्रैल तक अगर आपने फर्स्ट अपील फाइल नहीं की, एवरीथिंग इज ओवर, द डीलर हैव टू पे. नोबडी कैन डू एनीथिंग. इवन इफ कमिश्नर वांट्स टू हेल्प यू, कैन नॉट. You get it? So the appellate jurisprudence is totally different from the law what we have read. Now you have to apply that law. For example, हमें 73 की अपील फाइल करनी है, तो आपको पता होना चाहिए कि जो आपके पास नोटिस आया वो कौन से ग्राउंड्स पे. Whether those grounds are mentioned in 73. If you do not know 73, your appeal will be wrong 100%. It will have no meaning with the appellate authority. क्योंकि आपको कोट करना है कि आपका ऑर्डर within jurisdiction है without jurisdiction. If the order is passed on grounds which are not sustainable in 73 and 74, then you say this order is without jurisdiction. You have no jurisdiction to invoke section 73 on the ground you have mentioned in the assessment order. Now this is applied knowledge. What we have learned is academics. हमें 73 पता है, 74 पता है, 75 क्या होता है, ये क्या होता है, सब पता है. But now when an order comes before you, you have to see क्या ये ground बनते हैं. बनते हैं तो जज will draft appeal. This is appellate jurisprudence which is limited to interpretation of a particular provision against you. Appeal is in the form of a complaint, where you complain to a higher authority that this lower authority has not done justice to me. Your language आगे फिर तो कल का भी आप पोस्ट को आधा घंटा हमने बेकार किया लोगों को. सर आएगा इस क्लास में।
सर आएंगे, बिल्कुल आएंगे। It is our privilege.
मेरे को लगता है यार किसी भगवान की कृपा करके तो मुझे भगवान का